My name is Andrew Harris on behalf of the plaintiff. My trial counsel, Spencer Cooven, is here as well. May I have reserved 3 minutes for rebuttal, please?
Sure.
Thank you very much. We're here on a one issue, our entitlement to a new trial based on juror misconduct, and one juror in particular, Mr. Garudo. I know this court last week, which I thank you, sent an order out specifically requesting a discussion of 2 out-of-state cases, which I'll get to very shortly here, unless you all intervene, of course. But as we know here, we have a juror who extensively throughout trial was tweeting. The trial court's instructions could not have been clearer throughout trial. Do not discuss anything related to your juror service in this case. It was not limited to the facts. It was not limited to the evidence. What do we know from this juror? First off, he gives the most concerning comments. We're not here because of generalized vague comments. I hate to use the phrase, I half-assed my answers. In being picked for this jury, that in of itself, okay, what does that tell us? Then it's that comment in the middle of trial. Everyone is so money hungry that they'll do anything for it. This is a personal injury case. We're here seeking compensation for our non-economic damages and medical expenses.
But let's go on that last one. I mean, there was a hearing. The judge held. This isn't a case where you didn't get a hearing with the juror, and the juror gave on that last comment an innocent explanation for that issue, that it was something involving himself and his father and so forth. And so the judge, I mean, don't we have to believe that that Judge Kaiser, found that to be credible, and we're bound by that, aren't we?
Well, 2 things. First of all, obviously, the trial court made no findings. And in a couple of these cases, we have specific credibility findings. But the other part of what you said is an innocent explanation. I would strongly disagree that this was an innocent explanation. What this juror said in response to that question is, no, I wasn't referring to the plaintiff in this case. Okay, who were you referring to? My father and I were in a car accident a week before trial, and my father here in the middle of trial was served with a court order for that case. And so in response to that, he says, everyone, not some people, everyone is so money hungry they'll do anything for it. So what does that tie into? Juror non-disclosure in jury selection. The trial court's question in jury selection couldn't have been clearer. She described the car accident in this case. Plaintiff seeking compensation. Has anyone been in an accident or know anyone closely related, anything related to this, anything that sounds similar to this case, whether or not there were injuries, whether or not there was a lawsuit? A number of jurors chimed in at that point. Some were in car accidents, some were not in car accidents.
Didn't the focus of those question and answers by the other jurors center on claims made, injuries sustained, whether it settled in or out of court?
Your Honor, not just limited to that. One of the jurors chimed in about no injuries, just being served a lawsuit for a rear end accident, which this is what this case was. So it wasn't tied to just injury. It wasn't, I'm sorry, Your Honor, you have a
But
follow-up.
at the point of that voir dire, he had not received the papers that his father received, correct?
Sure, he had not. Well, we don't know that actually. We don't know that. All we know is his answer later on. What we do know is the accident already occurred. So he'd already had a car accident, he and his father. He knew about it, and he didn't answer that question. It was squarely asked for. The definition of concealment, and we're not just here under the juror non-disclosure test, but the definition of concealment does not require a finding of intentional lying, of intentionally hiding it. Was it a question which was straightforwardly asked for, and you didn't give the answer? And I would submit under the case law that was straightforward and not answered. The judge, after all the questioning from the juror, after the answers were given, followed up. Again, anything similar in any way, whether or not there's a lawsuit or not. So the question was, I would submit the question was straightforward. But the focus here, as I said...
What is the harm to, what's your argument for the failure of the juror to follow the trial court's instructions not to tweet, not to use social media? What exactly is your argument based on?
Sure. Frankly, it's not so much limited to social media, because it's that he voiced a comment, everyone is so money hungry. I half-assed my answers in jury selection, which ties to the juror non-disclosure.
You're saying it indicates a disposition towards your client involved in this suit.
Exactly. It's either partiality against our client or it's partiality towards plaintiffs in general, people seeking compensation. It so happens that there was a specific social media instruction in this case, which is where he expressly violated the trial court's instructions. If it had just been an instruction, don't talk to anybody about this case, about anything related.
But do you have cases that talk about the remedy for failure of a juror to follow the, does there have to still be prejudice that follows? I mean, if a juror doesn't follow the trial court's admonition not to tweet, then the question still has to be, all right, they didn't do it, what's the prejudice to your client? Is that was sort of like a two-part? First, you didn't follow it, and two, there's prejudice, and that's because this proves disposition against your client?
Well, actually, Baptist Hospital says the first part of the test, have we established juror misconduct? I would submit crystal clear there is juror misconduct here. Once there's juror misconduct, the burden falls to the non-moving party to show no reasonable possibility. We get a new trial unless no reasonable possibility that the juror misconduct affected the verdict. That's almost like the harmless error test, which we know is in civil cases. This was a case from 20, go ahead, Your Honor.
Yeah, one of the things I wanted to ask you, that back on the original thing, is that during voir dire, this is to me the problem, the thing you really need to answer for me in the case. During voir dire itself, this is my understanding, the plaintiff's counsel asked the jurors about their feelings towards personal injury lawsuits. And this juror responds something like, sure, some people need it, but I feel like some people also do it just for the money. I wouldn't say 80%, I can't put a number on it, but I feel like, sure, a good amount of people sue for dumb reasons. So what you're complaining about now that emerged in the tweets is really something that a red flag arose, it seems to me, during the voir dire, that he sort of disclosed some skepticism towards plaintiffs and plaintiffs' cases during voir dire. So, I mean, how can you now complain about it post-verdict when, it was disclosed during the voir dire itself?
Two things. For one, he also said that that there were cases where he would award damages. So this was not someone who was totally hostile to plaintiffs. But we're not just hearing a juror non-disclosure. Where you're getting into is materiality, which in order to find materiality, we would have to show, would we in all likelihood have used a peremptory? That's not what we're here for, because we had that tweet in the middle of trial and the undisclosed accident. That would have justified a cause challenge in this case.
When did the plaintiff discover the tweeting?
After trial. I think that record is clear, and under Roberts versus Tejada, there's no obligation, whether we agree with that rule or not. That's the current Supreme Court case law. And as plaintiff's counsel explained, he's a solo practitioner. He's not a solo practitioner. He was the solo attorney working on this case, so he didn't discover this until after the verdict.
Can you go back to Judge Gross's question about it? Because I'm really concerned about that. How do you differentiate what he said in voir dire from what we learned in the tweets?
Sure. The phrase everyone is so money hungry they'll do anything for it. That does not appear in voir dire.
So there's a certain amount of openness in voir dire, and there's no openness in the tweets.
Exactly. If plaintiff's counsel had moved for a cause challenge, that would have been denied. There's not an appearance of partiality from that juror selection. If that was the basis for a cause challenge, we know we wouldn't select jurors. Plaintiffs wouldn't be able to get a jury. We come in with people viewing us as ambulance chasers, and how do you award non-economic damages? You've seen cause challenges where people say that, and rightly, they're almost always
But they
denied.
said some people, sure, they need it, but I feel some people also do it just for the money. That's pretty generic. I mean,
Sure, I'm sorry, Your Honor.
No, go on.
Yeah, some people do it for the money, and some people have legitimate injuries. Here we are in trial. That's not what he said during trial. There's no ambiguity there. And that's all we have from him, is his unambiguous statement coupled with his non-disclosure. Because the non-disclosure is important, but the answer given in trial shows actual bias towards...
On that issue alone, what cases are you relying on, or should we rely on? There's no Florida case per se?
No, this is an issue of first impression in Florida. Demas Martinez from the Arkansas Supreme Court is the closest example of someone whose answers during trial tilt towards a possible bias. That was a death penalty case. But this isn't even a case of possible bias, and this is a case of actual bias from that statement. There's no way any plaintiff would want to have that juror have this person on the jury when he thinks everyone is so money hungry they'll do anything for it, coupled with an undisclosed car accident and his reference, if we believe him during his interview, which is questionable, but there are no credibility findings, where he tied it actually, no, I wasn't talking about this case, I was talking about my father having just been served with a lawsuit, some court order, because of the car accident we had a week before trial. Now, the cases that this court directed us to last week, those couldn't be further distant from this case, which is just like United States versus Fumo. We have generalized, vague ramblings from jurors. In one of those cases, Galinas, a juror talked about wanting to hang someone. It's not a death penalty case, it's a tax evasion case.
Plus, the judge didn't give a instruction at the beginning of trial on the tweets.
Correct. And even in the other case, Lou, if I'm pronouncing it correctly, it was a 3-week trial, and there was certainly frequent tweeting throughout that trial, similar to here in terms of the number of tweets, but that juror didn't again show any appearance of partiality towards one side or the other. At most, this was a juror who was a crime novelist. She disclosed that during jury selection, and basically her answers showed her frustration with the courtroom, her commute, and being interested in having writing material for her future writing events, whether it was the judge or the assistant state attorney. She had no indication of partiality or even appearance of partiality. So that's why those cases are significantly different. We cited as well United States versus Fumo. As another example, those generalized, vague assertions, which is what we frequently see. Let me make clear, if it wasn't made from the briefs, we're not seeking a new trial because of those generalized comments that he made during juror selection here. As disturbing as some of those are about not wanting to be a U.S. citizen and not wanting to sit on jury duty, we're not seeking that. That's not the basis for this new trial. That reality has been happening since the beginning of the jury system, probably in this country, where people who are served with their summons don't want to be there. What we have here, go ahead, Your Honor, I'm sorry.
No, I'm listening.
Oh, okay. We have that. We have a juror. We have him who admitted that he didn't even give complete answers, and then he contradicted himself in his interview as to what was the reason why he didn't give his answers. Was it because you didn't understand what plaintiff's counsel was telling you? Later on, he says, "No, Judge, you didn't do a good. You could do a better job in the future of making the questions clear for me." So he contradicted himself there. But we have that. Not giving complete answers. Then we have his explanation for not giving complete answers. And then, of course, we have that actual demonstration of bias, whether you want to call it actual bias, implied bias, inferred bias. To me, it screams out that comment. It couldn't be more clear what this juror is stating, telling the world. It happens to be his followers, but whoever had been on the receiving end, his feelings towards whether it's the plaintiff or plaintiffs in general. And if there are no further questions for now, I'll reserve. Oh, I'm sorry, Your Honor.
Is it plausible that the case description given by Judge Kaiser, at that point, he hadn't heard that his father received any papers, and he didn't make a connection between his father's lost automobile accident, which, if there were no injuries, he didn't know about any lawsuit, that he didn't think that it was related?
If we were just here, if that's all we had, if we didn't have the tweeting during trial, and we came forth with a standard, it's a Roberts versus Tejada 3-part juror non-disclosure test, I would still submit to you that that's concealment under the law. Was that question asked for? It isn't the subjectiveness of the recipient, it's whether the question is squarely asked for and not provided. So I would tell you that we would have concealment. But to the extent that would be a close call, that's not the case we have here, because we have what developed during the middle of trial, where that summons was received and where he sends out his tweet. Plus, we do have the other tweet that he half-assed his answers. So this is not a juror who, he's a high school graduate, he's in college, he indicated he gets good grades. This is not a language barrier juror. This is somebody who gave those inconsistent answers during his jury interview as to why he didn't give his answers. He clearly was scared at that point, and as someone would be, we're not here in a contempt hearing asking for sanctions against him or anything like that. But it's not just, the point is it's not just what happened in jury selection.
Suppose a juror forms opinions during the case, and because of the case itself, let's say it's a lousy case, and decides that the plaintiff is money hungry, so forth, and tweets that out, to his followers, just formed based on that. Well, if that's not a preconception, but is something that he's formed from the case. Why is that juror any different than a judge who's listening to a case go along and, forms mental impressions about that case? How does that necessarily reflect bias? It could reflect, a fair opinion about the case itself.
Well, two things. One, if you've prejudged a case, that would entitle a party to a new trial because, the express. But if you're forming mental impressions, we all form mental impressions. That's not what we had here. The other part is the juror in the interview didn't say his comments were based on the evidence. He didn't give any suggestion of that. He came up with this, it actually wasn't about it wasn't about the plaintiff here. It was about my father being rear-ended, which is the circumstance here, a hotly contested case of liability where the issue was who rear-ended who, where the jury significantly reduced the damages requested, where the jury apportioned fault, even though both parties presented diametrically opposed versions of the evidence. So it wasn't just forming, it wasn't tied to the mental impressions in this case. It was an express statement of bias towards the plaintiff or plaintiffs in general, which either way would entitle us to a new trial where the defendant cannot show no reasonable possibility that this affected the verdict.
Good morning. My name is Carrie Leininger, and I represent Michael Roth in this appeal. The trial judge followed the law and gave careful, measured consideration to the issues raised by the plaintiff. She conducted 4 separate hearings during the lengthy post-trial process in this case, including a juror interview. She reviewed numerous memorandums of law, and after hearing all of the arguments and testimony, she exercised her discretion and denied the motion for new trial. The plaintiff has to prove to you that no reasonable person would agree with Judge Kaiser's decision in this case. The plaintiff has not and cannot meet that burden in this case. The plaintiff has presented ever-changing theories to try to get a new trial in this case. The first theory was that the juror tweeted from the courtroom during the trial. Defendant proved with the timeline that that didn't happen, that this juror never tweeted from the courtroom and never tweeted during trial. The next theory was the juror's money-hungry comment is about the plaintiff and this trial. During the juror interview, it was demonstrated that that comment was a reaction to a court order that was delivered to the juror's father on day 3 of trial. So now they change up. Next theory, juror had a bias against plaintiffs in general, but failed to reveal it during voir dire. Again, the money-hungry comment developed on day 3 of trial. That money-hungry comment did not exist during voir dire. The money-hungry comment was a reaction to the court order being delivered to the juror's father on the evening around 8 o'clock at night on day 3 of trial. This last theory is this juror non-disclosure with an overlay of juror misconduct. And there's no case law to support the plaintiff's argument in this case. Dealing first with
Well, when you say there's no case law, you're saying there's no Florida cases, but isn't this a case of first impression? Are there any Florida cases that I missed?
No. There's no cases, Your Honor, where I've seen this mixture of juror non-disclosure and juror misconduct. And in fact, I can say that I think it's the City of Tampa versus Compiani case that actually rejected something similar where the moving party tried to combine juror non-disclosure with the failure to disqualify jurors who were felons. And the court in that case says you can't keep pounding a square peg into a round hole. And that's what's happening here.
You're not saying it's not juror misconduct. You're just saying it's harmless error to. Is that what you're saying? Because if the judge instructed not to tweet during or use social media, and the juror did, and then said everyone is so money hungry that they'll do anything for it, I mean that's juror misconduct, right?
Well, the tweeting is the juror misconduct.
Correct.
Right. And then the question becomes, is that misconduct, was that prejudicial? There needs to be a cause and effect of the misconduct. The misconduct has to cause a prejudice. So typically, when you're talking about juror misconduct cases, what the courts are looking for is, for example, one juror tells another juror, hey, this is how I'm going to decide this case even before deliberations begin. Or a juror goes and visits an accident scene. So there's a cause and effect of the juror misconduct. There is no prejudice caused by this comment or this tweet. No other juror read this tweet. And so there was no prejudice caused by it. What the plaintiff tries to argue is that this tweet reveals a previous held bias that was not revealed during voir dire. However, there is no proof that this bias existed prior to voir dire. This reaction to his dad being served with the court order, again, happens on day 3. There's no evidence that the juror felt this money-hungry attitude during voir dire, because all that had happened up to that point is there had been an accident. We don't know anything else about this accident. So all that happens at the time of voir dire is that there was an accident. And then what happens mid-trial is there is an order served. And most likely, because I think we all know, I think the accident happens on May 2nd. The juror's accident happens on May 2nd. The court order's delivered May 14th. It was probably some kind of traffic citation. But that money-hungry comment does not develop until after voir dire. So there is no concealment of that attitude. As Judge Gross pointed out, this juror shared a lot during voir dire. Shared that he thought that there were too many frivolous lawsuits. He also shared that...
But there's a difference from what he shared at voir dire and what he tweets. I mean, you would concede that.
Correct. There is. But again, there's no evidence that he held that opinion at the time of voir dire. And what the plaintiffs talk about is that he failed to disclose this auto accident. But he was not asked to disclose.
Wasn't some of the concern about that the judge and the instructions are to prevent people from formulating opinions, prejudging cases while the trial is going on?
I'm sorry, don't answer.
Prejudging the decision while the trial is going on?
Well, you shouldn't prejudge. The jurors are instructed not to make their decisions until they have heard all the evidence. But the jurors are also instructed that while they observe witnesses and hear the evidence, they should decide. Do they think this witness is telling the truth? Do they think the witness is lying? So jurors form impressions and opinions throughout the course of the case, and they are told that that is indeed what they are supposed to do.
So either this tweet is about the trial or it's not about the trial. So which is it?
The tweet is not about the trial.
All right, so it has nothing to do with the formulation of his impressions as it's going on, the juror's impressions as going on.
You're absolutely right, Your Honor. You're absolutely right. But it is also, again, an impression that there's no evidence he held that impression until day 3 of the trial, so that there is no failure to disclose. There were also some questions from the bench about whether this information, whether just an accident with no injuries, with no claims or no lawsuits, was required to be revealed during voir dire. The judge described this case as a case arising from an accident with injuries, and then asked the jury, has anybody been involved in a situation similar to that? Similar means an accident with injuries. That is certainly a reasonable interpretation of that question. And it was reasonable for any juror to assume that if I had just had an accident, but there was no injuries and there were no claims, then I don't have to reveal this information. And indeed, if you read through the voir dire, every juror who responded to that question had either an accident with injuries or an accident with a claim or a lawsuit. Every single one of them. Not a single juror responded with, I was in an accident, but that was the end of it. There were no injuries, no claims, no lawsuits. Every single juror who responds talks about claims, lawsuits, or injuries plus the accident. So this case is very similar to the Hood versus Valley decision, where, again, the jurors were asked a very broad question. Has anything about drinking that might affect your consideration of a DUI-related wrongful death case? Have any of you ever been in, is there anything about drinking that might affect your consideration of a DUI wrongful death case? Very broad question. The juror foreperson doesn't respond at all to that question. Later on, it's revealed by the juror foreperson that their father was an alcoholic. And so the issue on appeal was, did this broad question require that foreperson to reveal that their father was an alcoholic? And the appellate court in that decision said, no. The juror was not asked, do you have a family member who is an alcoholic? And the court held that that question was not precisely asked for. And the case law is consistent. It uses the words precise. It uses the words squarely asked for. This juror was never asked, have you ever been in an accident? Period. And there were never examples given. Well, even if there were no injuries or even if there were no lawsuits, have you had an accident? That was not squarely asked for. Therefore, the plaintiff has failed to meet the requirements of the juror nondisclosure analysis as to both concealment and as to due diligence. Also, as to materiality. A simple accident is rarely material to a BI case if it didn't result in any injuries or claims. So there's no case law that says just the simple act of being in an accident would have made this material such that we believe a peremptory challenge would have been used. And so the plaintiff has failed to show that the elements and prongs of the juror nondisclosure test have been met. I want to move next to just talking about the two cases that the court asked us to address. And both of these cases support a finding that the tweets in this case should not result in a new trial. There's a lot of the comments are somewhat similar. You're seeing a sort of a pattern that these jurors are tweeting about their jury service. But in the Ganias case, the juror, in addition to tweeting about the jury service issues, also makes some pretty strong comments before going into the courtroom. Hang somebody, I might get to hang somebody, and he's going into a criminal trial. And a response from somebody who views these tweets was, torture first, then hang. The judge interviewed this juror, and the juror said, I was just joking. And the judge found that that juror was credible, and the appellate court in that case, recognizing the discretion that a trial court has, affirmed the decision not to grant a new trial in that case. And then similarly, in the U.S. versus Fang case, again, you have the juror tweeting. And in fact, in that case, you had a first juror, juror 10, had been tweeting and actually got excused before the case went to deliberation. And then juror 2 continued to tweet. But again, the court looked at the tweets and did not find prejudice as a result of those tweets. And so on the juror misconduct issue, there has to be a cause and effect. The case law clearly sets that out. From the misconduct, what was the resulting prejudice? And in this case, there was no resulting prejudice from the tweet. And so we request that this court find that the trial judge properly exercised her discretion and the judgment should be affirmed.
Okay, thank you, Ms. Leininger.
Thank you, Your Honors. Real briefly, one, in terms of the plaintiff's ever-changing theory, there was nothing inconsistent with the theory. The plaintiff's arguments changed as the juror, they didn't change, they were amended as after the juror interview, because right during the interview is where this juror gave this explanation as to what he meant. So when you first see the phrase, everyone is so money hungry, the plaintiff reasonably thought, he's talking about me and he's talking about all plaintiffs, because I'm a plaintiff in a personal injury case. And then once we had the answer given, which is that he was actually, or he claimed, the juror claimed he was referring to his father's and his car accident, the plaintiff then informed the judge, look, we've got a more serious issue here because we have the juror non-disclosure issue, and we don't know what's going on here. Is it the plaintiff or is it all plaintiffs? Either way, the express bias was then revealed. Defense counsel talks about trying to compare this to Guineas, where their juror was joking about hanging someone. This juror here during the interview didn't say he was joking with his comment.
Guineas involves a Sixth Amendment right, and this doesn't involve a Sixth Amendment right. Does that argue that for a different application or a different way of looking at the case? I mean, they were willing to overlook conduct in a case where there's one of the most sacred constitutional rights. That right isn't implicated in this case.
I respectfully disagree that there should be any distinction in terms of we have a constitutional right to a fair trial. I understand the criminal implications and the due process implications here, but if the comments here don't warrant a new trial, I don't know how much further comments could go, because we're getting an insight into a juror's mind where they're not going to be likely to tell us and to tell the world what they're thinking. And this juror, did. Not just the generalized joking around about hanging someone. It was not a death penalty case there. He was interviewed. He told the judge he was joking around. This juror here actually expanded upon where his comment came from and tied it into his father being in a car accident, he and his father, and being rear-ended.
Okay. And let me ask you one more thing, just to see. I'm interested in what you have to say about this. There's a lot of talk that about the, and seminars are being held about the death of the jury trial. And if there's a too easy standard to allow a new juror, require a new jury trial when there's tweeting and conduct like that, wouldn't that further jeopardize a jury trial, because then as much time will be spent trying to undermine the verdict afterwards through social media, and we'll get more new trials, and it'll be more expensive, and it'll be yet another nail, as the proponents are arguing, another nail in the coffin of the jury trial. So doesn't that argue for a fairly strict standard here? That you would have to jump a high hurdle to?
The three-part juror non-disclosure test has been developed over the last, 25 years from the Supreme Court, and they have tried to put those limits with that test. And we would not be opposed to this court issuing an opinion to trial judges, obviously in our favor, but making clear that this is not about generalized, vague, harmless comments. That's what the United States versus FOMO did. That's even what the Arkansas Supreme Court did in Dimas Martinez. So the issue here is this expressed, clear statement in a personal injury case. If this was a tax case, if this was a landlord-tenant case, there would be a different analysis, just like when a materiality issue comes up, where this court, it's a bankruptcy. How did the bankruptcy affect you in that personal injury case? It's tied to here the nature of the allegations. It's tied to the non-disclosure issue, which it is, I'm not aware of it being in the city of Campiani that the issues here were there. But you do have a dual intersection of that tweet, of that expressed bias and the juror non-disclosure issue, which makes it, yes, this is a unique case. Thank you.
Thank you, Mr. Mayor.
Thank you, Your Honor, very much.